Good afternoon, everyone. We're still waiting for some people to join the call, but it is the National Healthcare Decisions Day. So if you give us just another moment, we're going to just allow some additional callers to log in. It's not quite 3 o'clock, so if you'll just bear with me. I know you're hearing silence, but you have in the room Eve Koopersmith, and Dee Dee Martin is here as well. So we're just, as I said, we're just waiting for some folks to dial in. I feel like I should sing a little song, only I have a terrible voice, so that's not going to happen. We'll give him another minute. Okay, we're going to get started. Again, I want to thank everyone for participating in the 2019 National Healthcare Decisions Day. Today's focus is Know Your Choices, Share Your Wishes. And for those on the webinar who are in the healthcare field, you know what we mean when we say how important it is to share your wishes, because that is exactly what healthcare providers want to know. They want to ensure that they are acting consistent with your wishes as an individual and as a patient. So let's get started. This is Eve Koopersmith speaking. Why is my not working? Here we go. Okay. So the purpose of National Healthcare Decisions Day, and this is the Mitch Rubino National Healthcare Decisions Day, is really to educate the public and healthcare providers alike regarding the importance of advanced care planning. And the whole purpose is to ensure that everyone has information and an opportunity and can access documents that are needed for healthcare decisions. We want to make sure it's available to all, and some of you know that there are electronic forms that also can be used at certain times. So this is something that is available for all decision-making capable adults in the United States to express their wishes in a manner in which those wishes can be honored at a time when they can't speak for themselves any longer. In New York, we have a healthcare proxy. Many of you know and have heard of that term. A healthcare proxy is a document that allows a person to name someone else, to appoint someone else to act as their healthcare agent to make healthcare decisions on your behalf in the event that you are unable to make those decisions for yourself. And the way that a healthcare proxy works is it comes in and out of effect. So for example, if God forbid I'm in a car accident on my way home from work and I am, as a result of that accident, incapacitated, my healthcare agent would be able to make decisions for me while I am incapacitated. But once I regain the ability to make decisions for myself, then my decision-making capacity would be restored and I would be making all of my own healthcare decisions. Some people are a little hesitant to sign a healthcare proxy because they They want to make sure that their healthcare information is private, and so they're afraid of signing a healthcare proxy. Well, an agent's decisions, an agent's authority doesn't begin until you are determined to lack capacity by your doctor. So it's not, your healthcare agent has no authority to access your medical records when you're making your decisions for yourself. They have absolutely no right to that information, and healthcare providers will not simply share with a healthcare agent your private information. Once you are determined to not have capacity by your doctor, that's when the authority of a healthcare agent begins, and that's when a healthcare agent would be entitled to have access to that part of your information which is necessary for purposes of making medical decisions. But it's limited for just medical decisions. So for example, and again, this is directed more to healthcare providers, even when someone is determined not to have capacity, their healthcare agent is not entitled to access a medical record for purposes of bringing a lawsuit. That's something different. A healthcare agent is only entitled to medical information for purposes of medical decision making. Now that's pretty broad, but it's not so broad as to allow access to a record for a medical malpractice case or some other type of lawsuit. They would have to go through the usual processes to access medical information and comply with all the other laws that protect the confidentiality of medical information. So, as I said, once you are determined by your physician to be incapacitated, a healthcare agent can make any and all decisions that you would have been able to make for yourself, including decisions about life-sustaining treatment. So a healthcare agent can sign a do not resuscitate order, they can consent to a do not intubate order, or any other measure, any other treatment measure that would be needed to sustain life. There are decision-making standards that apply to a healthcare agent. First and foremost, always, the healthcare agent must make decisions consistent with your wishes. That's why we started this focus about know what your wishes are and share your wishes. It's so important to have a conversation with your healthcare agent about your wishes concerning treatment and various treatment measures. It's one thing, and I've had cases where a patient has said, I want to live. The question is, how do you want to live? Do you want to live on a ventilator, if that is going to be the rest of your life? Do you want to live on a feeding tube, if that's going to be what you need to sustain the rest of your life? Do you want it only for a trial period? These are the conversations that are sometimes difficult to have, but we're coming up on holidays, and it's a good time. I know it might sound a little morbid, but not really, because we're talking about life. And so it's really a question of how do you want to live your life? And it's important to have these conversations so that when the time comes, you have someone who is appointed as your agent and actually knows what you want and can follow your direction. Now, in the healthcare proxy law, there's one limitation about when a healthcare agent makes decisions, and that's this second bullet on the slide that I want to call attention to. So to back up a little bit, an agent first must make decisions consistent with your wishes to the extent that your wishes are known, and to the extent that the agent does not know your wishes, then the agent must act in your best interests. And when they consider best interests, they have to consider the uniqueness of every person. They have to consider the type of suffering that you're undergoing, the likelihood of recovery, the impact of the treatment on you. So they must consider all these other factors and act as a reasonable person would act. But an agent is not permitted to make decisions about artificial nutrition and hydration which is a feeding tube and an IV tube, unless the agent knows your wishes or with reasonable diligence can ascertain your wishes. If the agent cannot ascertain your wishes and does not know them, him or herself, then the agent is not allowed to make a decision to withdraw or withhold those types of treatment measures. Now, Didi's here. You want to jump in?
Attorneys love to make up their own documents. So if you consult an attorney about, in addition to doing your will and power of attorney and to documenting your healthcare wishes, they often will love to present you with a multi-page document that incorporates to some extent what the living will is, and we'll talk about that in a minute. But we strongly believe, after representing hospitals and physicians here for over 35 years at Garfunkel Wild, that you use the Department of Health Healthcare Proxy form, which you can find on the New York State Department of Health's website.
Yes, actually, the New York State Bar Association also has a link. If you simply put into any search engine New York State Healthcare Proxy Form, you will come upon the form with instructions. I'm really glad you brought that up, Didi, because I can't tell you how many times, acting in the role of hospital counsel, we are presented with a healthcare proxy form that a lawyer created, and it doesn't follow the law. It's not correct. Perhaps it was notarized and not witnessed properly. The healthcare proxy form that was developed by the New York State Department of Health was developed for the purpose of being able to be signed around a kitchen table. The whole point of it was that you could download this form on the internet or obtain it in some other way, and you could sit around a kitchen table with your family and follow the instructions and fill it out. It was supposed to be very easy to be done, and it is very easy to be done. And all healthcare providers have the New York State Healthcare Proxy Form available, and in fact, it is often part of an admissions packet when a patient is admitted to a hospital or admitted to a nursing home. It's part of the information that is presented to a patient on admission to give them information about how to make advanced directives. Now, it's true that on the healthcare proxy form, you can list what your instructions are. Our practice tip that we recommend to everyone is that the only thing stated is that my agent knows my wishes regarding artificial nutrition and hydration. And the reason we put that in there is exactly for the reason that's stated on this bullet, because your agent would otherwise not be able to make those decisions. Of course, you should then tell your agent what your wishes are so that they do in fact know, but put that on your form so that when you go to a healthcare provider of any type, they're going to recognize the form. It will never go, if all the blank spaces are filled out where they're supposed to be filled out on the form, then the nurses, the doctors, everyone who's presented with that form, the nurse practitioners, they all know what it looks like. They're going to say, oh, it's a healthcare proxy. I see, this person is the healthcare agent. We can just turn to them. And everything will happen smoothly in terms of transitioning and arranging for all appropriate care measures. We never want to stop providing appropriate care measures because we don't know who the decision maker is. So it's always a good idea to use the New York State form. Thank you for mentioning that, Didi. And actually, before we go to living will, I'm just going to back up and one more thing about a healthcare proxy. On the healthcare proxy form, you can also state whether or not you wish to make an organ donation. And so while we're just talking about a healthcare proxy, and we'll talk a little bit about that later, I wanted to mention that on that proxy form, again, using the state form, you can indicate whether you want to donate tissue or organ, and that has to be signed separately. So there's two signatures on the New York State Healthcare Proxy Form. One is just for the proxy, and then it's a separate signature if you wish to be an organ donor. So let's move on and talk about a living will. A living will is different from a healthcare proxy because a living will is a document that expresses your wishes. That's the purpose of a living will. It's to allow you to give instructions about medical treatment that you do or do not want under certain medical conditions. A living will should marry the medical treatments that you want or do not want. It should marry those instructions with the medical circumstances that you want those instructions to apply. So people will say things like, well, I want to be a DNR. But the question is, under what circumstances do you want a DNR? When do you want that to apply? Most living wills will say things like, if I'm ever in an incurable or condition or have an irreversible condition with no reasonable expectation of recovery, or it will say, in addition to that, it would say, or if I have or my mental capacity is so impaired that I am permanently unconscious or in a persistent vegetative state, then I do not want cardiopulmonary resuscitation. I do not want intubation. I do not want artificial feeding and hydration, and whatever those instructions may be. So one of the things that's important and that healthcare providers have had to face regularly is that a living will, which is a series of instructions, provides direction to a healthcare agent who's been appointed under a healthcare proxy. And so in some cases, we've had situations where a healthcare agent is making decisions which are not consistent with the living will. And that presents a problem because healthcare providers must honor the directions of a patient that were made at a time when that patient had capacity. So if a patient made a living will and the provider is presented with a copy of that living will, and now a healthcare agent is making decisions that are not consistent with the living will, that is a reason for further conversation. Perhaps the living will was revoked. Perhaps there were later conversations that the healthcare agent had with the patient. And now the healthcare agent must provide information to the healthcare provider that, in fact, there were these later conversations and instructions. So it's important, again, to always have these conversations. As we go through life, we go from hopefully having good health with no medical conditions to if we have medical conditions, hopefully they're able to be managed with medication. But then as we approach more end of life, our condition may change and our views may change. As we progress in life and we may become more ill or more infirm, we may have different views. So this is not like a one-stop and you're done. It should be a continuing conversation. A healthcare proxy is the most flexible document because it simply allows you to have conversations with your agent and then your agent can continue to act. Of course, if something happens to your agent, you have to update your proxy to ensure that your agent can still act on your behalf. We have that with husbands and wives where, partners where one partner may predecease the other and they need to update their documents. But having a conversation is always a good idea. And even with that living will, if you should make one, because what happens if something happens to your agent and you're in a place where your agent can't be reached, you might still want a living will. It's important to then update it when your wishes change so that it's consistent with your current views.
But the most important thing is to select someone that you know will carry out what your wishes are. And the living will ideally is a backup. It's ammunition to that person so that they can demonstrate, if they're ever questioned, that what they're asking the healthcare provider to do is what you would have wanted. There are circumstances where perhaps the person you've selected is unwilling to carry out what your known wishes are, and then the proxy would be contrary, and that would be the cause for them to consult with their attorneys. But ideally, you will select someone that you know is going to respect what your wishes are. And we have, in our conversations with our clients over the years, had a husband or wife choose someone other than their spouse because they know that their spouse, and they tell them at the meeting, I'm going to choose somebody else because I know that they're better suited. Or when they have several children, they might not pick the oldest or the one that's the physician. They might pick the one that they know will respect what their wishes are in that regard. So that's the most important thing, is picking someone that you know is going to carry out what you would have wanted in that situation as best they're able to understand what your wishes are as you've explained it to them.
That's a really good point, Dee Dee, that in choosing and selecting a healthcare agent, you choose someone who will honor your wishes. And it's particularly important because if you don't have a healthcare proxy and you don't have a living will, and you happen to be in a hospital or a nursing home, we do have the Family Healthcare Decisions Act, which allows a family member to make medical decisions on your behalf. But the family member is going to go in order of priority of a list. So first it would be spouse, then it would be adult children. Now, the Family Healthcare Decisions Act doesn't tell you which child. All of the adult children are on the same level of priority, so they would have to agree, but they don't always agree. And if the closest relative to you is someone who you know will not honor your wishes, it's an even greater reason to ensure that you sign a healthcare proxy and name someone that you trust will follow your wishes. The other thing it's important to mention is we see families all the time who come in and want to name all of their children because they love all their children equally, so they don't want to pick one. But with a healthcare proxy, you have to pick one. You can have all three serve one after the other, but they have to serve one at a time. You can only serve one at a time. That's one of the requirements of the healthcare proxy law. So let's move on and talk about do not resuscitate orders and MOLST. So there are many times people come in and they say, I have a DNR, and what they really mean is they have a living will that says what their wishes are, but they don't actually have a DNR, a do not resuscitate order. A do not resuscitate order is an actual physician order that the person should not be resuscitated in the event of either a cardiac arrest or pulmonary arrest, meaning your heart stops or you stop breathing. And that's all that a DNR is. Even if you have a do not resuscitate order, the person should receive all other appropriate treatment measures. And just because you have a DNR order does not mean that you will not be intubated. There are times that a person has to be intubated to protect the airway or for some other reason. They may be having trouble breathing. A DNR order does not apply to that. So a DNR order, as I said, is signed by a physician upon your consent, and a DNR order actually refers to an order that is signed either in a hospital or a nursing home. But if you are living at home in a private house, or you're living in an assisted living facility, or actually it could be an independent living facility, you must have what's known as a non-hospital DNR that is signed by your physician. And the non-hospital DNR order is a form that is created by the Department of Health. It's a one-page, 8.5 by 11 paper that doesn't say very much other than non-hospital DNR order. In the alternative, you could have what's known as a MOLST form, which is Medical Orders for Life-Sustaining Treatment. That's what it's called here in New York. Elsewhere in the country, it's known as a PULSE, Physician Orders for Life-Sustaining Treatment, but here in New York, it's Medical Orders for Life-Sustaining Treatment. What's interesting about the MOLST form is it is a hot pink form, and first of all, it stays with you through all patient care settings, which is very important. It stays with you whether you're in the hospital or whether you're in a nursing home or whether you're in an assisted living facility or whether you're at home. That form stays with you. So you don't have this issue of non-hospital versus hospital DNR having to be issued and reissued. It just stays with you. The other important factor about a MOLST form is that it is more encompassing, and you can have other instructions that apply. So a MOLST form can also include a do not intubate order. It can include no artificial nutrition or hydration. It could say, I want a trial period of artificial nutrition and hydration. It might say no antibiotics. You can list other instructions on the form, and you can also say no transfer to a hospital. A MOLST form is only appropriate at the time of the end of someone's life, because these are actual physician orders. Let me distinguish between a living will and a MOLST form. A living will says, I don't want these treatment measures in the future, if I should have these conditions in the future. A MOLST form says, I don't want these treatment measures right now. And not only do I not want them, I've consented to this, and there's a physician order directing that these treatment measures not be provided. Now, I'm using the word not, but I want to be clear that on the MOLST form, you can actually say, I want. So it could be one or the other on a MOLST form. It could say, I want all treatment measures. I want to have cardiopulmonary resuscitation. So a MOLST form are physician orders that are applicable right away. And it's not based upon any determination of incapacity. It can be completed in stages. So again, as I talked a moment ago about how we advance our condition in life, our medical conditions may advance. We may have more infirmities. We may change our mind. A person may start with a DNR and then say, you know what, I don't even want to be intubated. I don't want this, or I don't want that. Or I want a trial of this. And there are treatment decisions that they may not be ready to make, that as their medical condition advances, they then may be ready to make and want to have documented on a MOLST form. So the MOLST can be updated. It must be reviewed regularly by your treating practitioner. And again, it's that hot pink form that stays with the patient through all patient care settings. Now, I want to mention that just, I guess it was about a week ago, the New York State Department of Health updated the MOLST form and the non-hospital DNR to now show that a nurse practitioner who has the primary responsibility for the treatment and care of a patient can issue a MOLST form or a DNR order. The nurse practitioner law was changed last fall in November, I think, of 2018. And in April of this year, the Department of Health actually changed the forms to now demonstrate that on the form itself, where it says physician, it now says physician or nurse practitioner who has to sign the form when it's being issued. So I just want to mention that to you too. If you have, you can go to the DOH website, and there's a link to the new forms, which are available online. Both the non-hospital DNR and the MOLST form are available online. If you are downloading those forms from the website, you have to use the Pulsar pink paper for a MOLST form. The reason it's hot pink is because everybody knows what it looks like. And let's talk about that for a moment, because, in the community, in the field, when someone is at home, as I said, they have to have a non-hospital DNR for that to be honored. And all emergency responders know what a non-hospital DNR looks like. They know what a MOLST form looks like. If you present them with those forms, they will honor the orders that are listed and signed off on by your treating practitioner. They will honor that in the field. They will not honor a healthcare proxy, because remember that your agent's authority doesn't begin until your doctor determines you don't have capacity. So there is case law on this where, the wife said, I'm the proxy, my husband never wanted to be resuscitated, don't resuscitate him. And the EMS said, move aside, ma'am. we have to resuscitate him anyway. We can't make that decision. It doesn't matter that he's not responsive now and can't speak for himself. We cannot follow your direction. We must resuscitate him. And in fact, the courts have held that that's correct because your doctor has to make that determination. So in a community setting, if these are measures that are appropriate for you, it's important to have these forms completed so that your directions, again, can be honored. I just want to talk a moment about safe drug disposal. This is a big issue for the environment as well as for safety for both humans and animals. So it's important not to flush unwanted household medications or pour them down the drain. There are collection events, usually twice a year. I think there are collection events, so you can return the drugs at a collection event, or you can also mix medications with undesirable things like cat litter and coffee grounds or dirt. You have to mix them and then put it in a container and tape up the container, seal the container as best you can, and then you can toss it in the garbage. But again, the whole point is you need to make the medications unappetizing and not available so that animals also won't be able to get into it and ingest these unsafe substances. The next slide is on organ and tissue donation. We did indicate earlier that you can state your wishes on the healthcare proxy form. You can also register for organ donation online. And in the webinar, we've included the web address to indicate if you wish to be an organ donor. You can indicate that you are a donor on your driver's license. And your healthcare agent and surrogate a surrogate under the Family Healthcare Decisions Act is also authorized to make a decision on your behalf regarding organ donation unless you've stated your wishes to the contrary. And I do want to note that I recently heard that New York State, the percentage of folks who are organ donors in New York State is down this year, and we have a higher need than what we're able to service. So it is very important to consider whether you would be willing, and if you are, to indicate that you are willing to be an organ or tissue donor on any one of these mechanisms. And while we talk about electronic forms, I should also add that the MOLST form is available in an electronic form as well, in an eMOLST form, and there are many communities that are using, many healthcare communities that are starting to use the eMOLST as a way to just make it easy when there's information sharing so that the wishes are known by all the healthcare providers and they can honor a person's directions. So that's something else to consider.
The next slide, which we did try to put them in some sort of natural progression here. Now we've thrown out the drugs that were left over and the organs or tissues have been donated or not. And now the question comes to funeral arrangements. In most cases, this is not an issue, but sometimes it will happen that people who are estranged from you, it could be a spouse, it could be a child, are asked at the time of your funeral arrangements being made to sign off on what's being authorized. If you do not want your spouse, or if you don't have a spouse, one of your children, or you think there will be a disagreement among your children, or if you don't have children, let's say your parents, or if no parents, your siblings, aunts and uncles, whoever it is in that order that the law allows, you do need to do what's called the Disposition of Remains form that you select, much like the healthcare proxy, who your agent will be for making your funeral arrangements. You can plan your funeral arrangements in advance with a funeral director. You can pay for them in advance, and you can indicate if you have specific wishes that you want to make sure they're honored. And the funeral director then is bound to follow the person that you've selected. So it might be that the person that by law would be entitled to determine how your remains are disposed of is not the person you would want doing it, or you may have unique wishes that you want to be carried out and you're not certain that they will. So that is another form that more and more especially if you're not married and you want someone who is a significant person in your life to making those decisions, and that can be obtained from an attorney. It's a state statute that provides a form.
That's another good point. In many of our statutes now, our statutes have been written in a way to recognize that you may have a domestic partner, someone who is not your spouse, but is a domestic partner. And domestic partners stand in the same role as spouse whenever you haven't made a prior selection. So a domestic partner is a surrogate on the same level as a spouse to make healthcare decisions. And I think domestic partner is also on the list in terms of disposing remains. So if you happen to be someone who may have been divorced, or you've survived another spouse, and now you're in a second relationship where you're sharing household expenses, and this is someone who's important to you. You're not married, but you are in the role of being a domestic partner. That person is going to take priority over your children, over your adult children that were from a prior marriage. So these are areas that become areas of disagreement, and it's important that if you're in that type of a situation, it's important to consider what you want and who you want to be in control, and make that selection and choose that agent so none of these issues would come up.
Now we're going back to you being alive after we've gone through all those grim forms. In addition to dealing with healthcare matters, another very important document to allow you to still have control by selecting who you would want to be making decisions about financial matters is a power of attorney. New York State has a published form to follow. Lawyers, and here we do like to tinker with it and add additional provisions, but just like the healthcare proxy, you're selecting someone to deal with your financial matters, whether it's looking through your mail, paying your bills, making investment decisions, taking your IRA distribution out, making arrangements for the care of your dependents. This is something that you need to select also. You need to pick someone, and here you can select more than one person, and you can indicate if they must sign things together or can act separately and independently. But you need to select someone that you understand will carry out your wishes regarding your finances and act in your best interest in carrying out whatever your plans are. If you don't have a power of attorney signed, then no one has authority to act on your behalf unless they are also on an account as an owner or own a property jointly with you. And in that case, you would have to go through, or someone who's interested on your behalf would have to go through a proceeding to be legally appointed your guardian. And as Eve can tell you, that is a long, expensive, contentious, and difficult process.
Certainly can be, particularly if there are family members that don't agree. And the guardianship process is an adversarial proceeding. If you don't want to have a guardian appointed for you, you're entitled to object. You're entitled to ask for a jury trial. You're entitled to counsel. And it certainly can be a very contentious proceeding that can be litigated over many, many months, sometimes longer. More often than not, these proceedings are not as adversarial as that, but they are certainly costly, and they cause delays in attending to your financial affairs when things need to be addressed quickly. And I actually just spoke with a client this week about trying to help her mother, and mom never signed a power of attorney. So, what they want to do to try to protect her interests and protect her finances for her benefit, they cannot do in the absence of having a guardian appointed. And it's difficult for family members to want to commence a proceeding against their loved one. At the end of the day, let's remember that, we're talking about people who care about each other, and they don't want to take legal action against someone whom they love. It makes it very, very difficult.
I've found that people are often more reluctant to sign the power of attorney than the healthcare proxy. I think they think when the time comes for the proxy, they will be in a state that they are willing to put themselves in someone else's hands. But with finances, and it is usually a document that's immediately exercisable, although you can have a provision for it to be springing. That adds another layer of medical decision making in that can delay the power of attorney's effectiveness when time may be of the essence. And I'm sorry. And it's extremely important to select who that person is and take control by deciding who that agent will be. And you can also revoke a power of attorney very easily by destroying the documents. Having a guardian appointed, it's not anywhere nearly as easy to change your mind and say, I don't need assistance anymore and I can handle things on my own. So again, selecting a power of attorney, having someone you trust, expecting that they're not going to do anything that is not in your best interest is the preferred way to go.
Well, a power of attorney also, the agent who is acting under a power of attorney has fiduciary obligations.
They can only act in your best interests. You can also, if you really feel that you're not willing to take that step, you can appoint someone as a monitor over that agent who would be entitled to receive from the power of attorney updates, financial information to make sure that they're only doing things in your best interest. And again, you can also appoint two people and require that they act together, which adds a layer of complexity in getting two signatures when something needs to be done. But that would give you another basis for being more comfortable if your choice of agent isn't obvious as to who in your life that will be. The next thing that you need to consider is having a will. A will appoints, again, that agent that will make sure your wishes are carried out. They will gather your assets. They will see if they need to go to court to probate the will. They'll examine the titles on the different properties, and then they will take what you've said about how your assets should be distributed, and again, they're legally obligated to report to those people who you've chosen as your beneficiaries how they've come to distribute the assets of the estate. The will can be very simple and only a few pages long. Appoint an agent called the executor, say where the assets go, or it can get more complicated by if you have a beneficiary that needs to be protected, who can't manage funds or is disabled. If it's a second marriage and you want to make sure that after you've provided for your spouse, after their passing, that it goes back to your children from your first marriage. And most importantly, if there are things that you think your beneficiaries are going to disagree about, the will allows you to reduce or prevent that tension by stating what your wishes are in that regard, whether it's a piece of jewelry or an interest in a family business. These are all things that can get addressed in the document and hopefully result in your plan being respected without the need for family disagreements, more lawyers, and delay. Another thing that is important is that a will is not a magic wand that waves over all your assets and distributes them as you've said in the will. You may have opened up a joint account with someone, and if it has what's called rights of survivorship, that will pass to that other person automatically. It doesn't go in your will, and your will isn't able to change that. You may have designated an account in trust for, ITF, which means it will pass to that person at your death automatically. Or you may have named a beneficiary on a life insurance policy, an annuity, a CD, an IRA, or another retirement plan. And all those things pass to the person who's named. The will, if it says someone else, will not override that. So it's really important to make sure that when you sit down with an attorney, you tell them about all your assets, and you maybe go back and do your own research to find out if you've listed beneficiaries, and if you haven't, made sure that those are updated to reflect what you want, because so much of the assets in an attempt to, quote unquote, avoid probate will pass according to those designations and not to what you've said in your will, which might be different. And I think that brings us to the end of our explanation of what the basic documents are that we think you should have so that you can take charge and stay in control. And that's the message of this, is that by making your decisions now while you're healthy and able to take stock of everything and understand what your plan is, that you are in control. It's not giving up control to others.
It's absolutely true. So the last slide just lists all of those documents that we discussed today: the healthcare proxy, a living will, MOLST form, DNR, a disposition of remains form, a power of attorney, a last will and testament, and then, of course, the beneficiary forms on your accounts. The only thing we did not mention is a HIPAA release. That is something that is sometimes done also in estate planning. A HIPAA release, if you remember, I said earlier that your healthcare agent is not entitled to get access to your medical information unless you do not have capacity and the agent's authority has been triggered. A HIPAA release is a document that you would sign that allows whomever you choose to have access to your healthcare information even when you're making your own healthcare decisions. So that's important to consider if you want your spouse or someone else whom you trust and who is involved in your healthcare, perhaps an adult child. Perhaps you want, if you have a child going off to college, you may want your child going off to college. If there's a health condition that they have, you may want them to also sign a HIPAA release so that you can have access to health information while they're away. In the absence of a HIPAA release, you would not otherwise be entitled to get that type of confidential information. So that concludes our program for today. I want to thank everyone again for participating, and hope that you can spread the word. And if you haven't done a healthcare proxy for yourself, please do one right away. It's important to have that. Consider some of these other documents that are needed for you. Thank you again. Bye-bye. Bye-bye.